important thing. If without the owner's consent, you use this property for a statutory period of time, which in Florida is 7 years, that can create an easement by prescription, which is using it adversely to the other owner without his consent. That's called prescription.
I'm sorry, are you referring to squatting?
I'm sorry?
Squatting, do you refer to squatting like?
Squatting is actually occupying the property. And that is the concept. In the adverse possession concept of this, where I said in the bigger picture of prescription is adverse possession, yeah, that's squatters. But under Florida, as you'll see when we get into the Florida statute, it's very difficult in Florida to become the actual owner of property
They can't.
as a squatter. It's tough.
So,
Yeah, you have to pay the taxes, you have.
I guess a typical example would
But
be.
that's not even this chapter. We're not even going to go. I don't mean that disrespectfully, but I brought it up, but I wanted you to understand the concept is using somebody's property. Remember the difference here. In this context, we're talking about using somebody else's property, but not occupying. This is a non-possessory right, which is an easement, which is using somebody's property. A squatter possesses the whole thing. It's all under the same heading of prescription and adverse possession, but it's not an easement. Yes. Yes, sir.
How long was the time frame you said?
Well, there are several different time frames under Florida law. They're all based on 7 years, but there are a couple of different tests that go with them, but we'll talk about that separately. As for this in Florida, it's 7 years to use a guy's property without his consent. But all that gives you is an easement. It doesn't give you ownership in the context of an easement. It just gives you the right to use it. And thereafter, the concept is, here's the concept that runs through all this stuff. If you get in somebody's face long enough, and he doesn't do anything about it, then the law is going to give you rights. And that's what all this is about. It can't be with his consent. If it's with his consent, he gave me an easement, right? Okay. We're saying if you use it anyway without his consent, maybe you can get an easement. That would be an easement by prescription. And in a different context, if
I'm
you're a
just thinking
squatter,
like agriculture or something, you're planting a farm, a mini farm on someone's property.
that's one of the tests. One of the tests is if you farm it, if you fence it, if you pay the taxes, if you maintain it. There are all these different tests that work into the different statutes. In this case, though, it's simply if you use it for 7 years, you may get the continued right to use it. You still don't own it.
Yeah.
We're just talking about getting an easement here without having a guy write one up to you. Okay.
People are pretty, if it's worth anything, people are very protective of their easement, so they're not gonna let you.
It is an extension of the concept of easements and the concept of prescriptive easements we just talked about, to say, hey, let's say this is east and west, and the sun comes up over here, and it crosses over this way. All right. This guy, conceivably, has gotten to have the benefit of sunlight crossing this guy's property for many, many years. What happens if this guy builds a 30-story building and you don't have any sunlight anymore? In the morning. Afternoon, you're going to be fine, unless this guy does it too. The concept of, under our talk about a prescriptive easement, is I never had this guy's consent for the last 100 years to get sunlight or air across his property, but I did. Does that give me a prescriptive easement over his property to get air flow, to get sunlight? Because for all these years I've had it. is that considered to be a prescriptive easement by prior use? And the court said no. And there's a great case in the book, and this is one of the few cases in the book that I ever want to call your attention to. But the cool thing is because it's something we can all relate to. It's on page 207, and it comes out of a Florida appellate court. And what you're looking at is a court's opinion, like we talked about before, that creates precedent for other courts. And here's kind of a cool story. Two Fat Cat hotels on Miami Beach, the Fountain Blue and the Eden Rock, are next to each other on the beach. And one of them wants to add a 14-story extension upward onto his building, add on another 14 stories. And what happens to the pool and the cabanas and all the stuff for all the sunbathers, snowbirds, when the 14-story thing goes up there and blocks the sun all afternoon?
It was
Is
the
it all
northern
right?
building?
I'm sorry?
Was it the northern building?
It was the Versailles.
Well, these are eastern.
I think it was the Versailles.
No, I mean along,
I don't remember which was what. I don't remember who was building. You can read the case and see either Eden Rock or Fountain Blue. I think Fountain Blue was going to get 14 stories higher. And of course, in the let's see, in the summer where the sun would go down to the south, if the southern building got taller, it would block the sunlight hitting the northern building. Interestingly, the Florida court said, we've reviewed the law in all the states, and we don't believe that there is a right to sunlight. That there is that there is no prescriptive easement for sunlight, and that you're not entitled to get sunlight across your neighbor's property, so long as the neighbor's following the building code and stuff like that. You know, if you were building a grain silo, and those are prohibited, well, then that's something different. But if you were building a grain silo and the zoning allowed it in a farming community, and that shadow of the grain silo meant your garden got no sunlight, that's tough. The court said you are not necessarily entitled to an easement across your neighbor's property for sunlight. On a case that we can all kind of relate to. Yes, sir.
Would that hold true also for views, for example?
For view,
Yeah.
there's a lot of talk about view, and I don't know whether there are cases yet on view, but a lot of people are complaining about it. Blocking your view of the waterfront, you know? The materials only talk about light and air. But you hear people talk a lot about losing their view of the ocean.
I mean, that diminishes property value tremendously.
Yeah, no question that it affects your value. I guess the question is, are we going to burden a property owner who is building in accordance with the building code, telling him he shouldn't be able to use his property and he shouldn't be able to build on his property because it messes up my view? I don't know. That's what courts are for. I don't know the answer to that one, but a lot of people talk about that. I had a great view of the intercoastal, and they built a condo out there, I can't even see it anymore, you know? I don't know the answer to that.
But what about the one with the sunlight for the sunbathers? I mean, that's bringing tourist dollars to our area. How much?
What are the damages? Sure, people quit coming to your hotel, and,
Yeah.
you know, yeah, court said no. It's just not something you get your eye on. Now, I guess, and candidly, I don't know that you can get well by building a 14-story addition on your property too. I don't know that that improves your situation at all, you know? In any event, the courts have said that is not an easement by prescription, but that's a kind of a cool argument. Hey, I've been using your property for the last 100 years for sunlight and air. Can't take that away from me. Yeah, you can. Question?
No, I was just gonna say, I think they worked it out, where it's gonna have that overflow of, hotel guests. We used to send them there and, you know, do different things like that, and parking as well.
Oh, parking,
I
yeah.
think
Oh,
we
parking,
worked out-
parking
they worked
easements are
something
big,
with-
yeah.
With that, in that regard, that I remember.
Okay, that's a good case, and it's well written, and you can follow it, and everything you read in it makes sense. There are two more concepts I want to talk about. The first is kind of a no-brainer. Once you've got an easement, how do you terminate it? first one's pretty obvious. And the second one is less obvious, but it's common, and the rest of them are absurd. So I want you to learn the first two that we're going to talk about. The first one is called a release. Pretty obvious that if A signs a document that says, I release my easement, the easement goes away. That's kind of a no-brainer of how do you terminate a document. Whoever has the easement releases it. They'll terminate it. The second interesting concept is the concept of merger. And that says that any time the dominant and the servient estate, the dominant estate and the servient estate are owned by the same person, that kills an easement. And if you think it through, sure it does. If one guy owns it all, you don't need an easement anymore. So you wouldn't even need a document killing that easement. That's the doctrine of merger.
So if you subdivided it again, would the easement not be there?
It's gone. It's gone.
Okay.
You'd have to create it again.
Okay.
That's the concept. The concept is called merger, and we're going to see. The concept of merger can apply in all kinds of situations. This is the first time the materials tee it up. But let's say under this situation where we had a life estate. Remember we had a guy with a remainder? Well, if all of a sudden this guy bought out the life tenant, there's a merger of the two estates, and therefore there aren't the two estates anymore. Similarly, if this guy sold his interest to this guy, the point is there are no longer two separate estates. It's the same concept we're saying here. If there are not two separate estates, which means two separate owners, then whatever these rights are going to go away. You can have it in a leasing situation where the tenant buys the owner's title. The lease goes away because there's a merger of the two estates. Here, the life estate goes away because the two estates merge into one. Similarly here, if the servient estate merges into the dominant estate, you have merger, and that extinguishes an easement. Those are the only two important things to know from the section of how do you get out of an easement. Whoever has the benefit of the easement can release it, or both parcels are owned by the same party. Same concept would apply, frankly, if in this situation FPL bought lot 1. FPL doesn't need an easement anymore, they own lot 1. So it could even apply to an easement in gross. The point is, when the property burdened by the easement is owned by the same person that has the benefit of the easement, it's going to go away. Now, there is another type of right to use somebody else's property that's called a license. Remember, an easement is a right to use somebody else's property but not possess it. And it's irrevocable. A license is the right to use somebody else's property, but it's very short term and it's for a very limited purpose. There are some good examples in the text. I don't remember if the ones I wrote down were the ones from the text or the ones that I remember. Like a theater ticket. You got the right to use a movie theater for 2 hours. That's a license. You have the right to use somebody else's property for a limited purpose for a short period. A ticket to park your car in a parking lot. A camping permit from the state park to camp overnight. You don't get any real long-term rights on the property. They are revocable, not irrevocable. And lastly, you can't transfer them. An easement can be transferred. FPL can transfer the right to Southern Bell. But in easement in a license situation, they're not transferable. It is very hard sometimes, though, to distinguish between a license and an easement in gross. Because we're saying it's not attached to a specific piece of property. The best way to tell is that a license is something that is intended to go away in a very short period of time. Whereas an easement in gross is intended to be permanent, but it doesn't relate to a certain piece of property. Yes, sir.
Let's say that you have a license agreement to use someone's property, or the rights to use someone's property. It is short term, but let's say you renewed it, it's a 1-year license agreement, you renewed it 10 years, for 10 years consecutively. Does that essentially give you, was it easement by implication?
No.
Doesn't it?
But you have, no, I'll tell you why. In the prescriptive easement situation, as we talked about, it has to be against the owner's will. It has to be hostile and open and not with consent. And a license is consent. A 10-year license is consensual from the owner. I don't think you're going to have a 10-year license, though. You're going to see licenses to be in a construction situation. You give the contractor a license to park his construction trailer on your piece of property during the term of the job. Not intended to be permanent. When our construction contract is over, I expect you to get that thing out of here. But I'm not giving you any rights in my property. I'm not allowing you to be able to transfer those rights to anybody else. They're strictly personal to you, the contractor. They're for a limited term and for a limited purpose. Now, easements and licenses are for a limited purpose. But an easement is intended to be permanent. And a license is intended to be short-term and go away. But as I mentioned to you, it can sometimes be hard to tell. And the best test that I always see is it short-term, is it long-term? And you know, in short-term, in our context there, I still consider the right of a contractor to put his trailer there for 6 months to be short-term. And the absurdity of the examples is a movie theater ticket, well, that's for an hour and a half. Well, that's pretty short. But you do have the right to occupy that theater owner's piece of property for an hour and a half. So that's a license. Now, licenses are considered much less formal, much less dignified. They don't really create a transferable or permanent interest in a piece of property. The point being, if you're giving somebody the right to use your property, try to give them a license. If you're trying to get the right to use somebody's property, try to get an easement. Give the better one, get the better one when you can. Give the lesser one when you can get away with it. That's the end of the material. I want to talk a little bit about what we're going to do next week. Talk a little bit more about the exam. And then we're done. Next week, we're going to talk about, in greater depth, in Chapter 10, the basics of contracting law, of contract law. More of the stuff we talked about you have to have consideration and you have to have a legal purpose and all that, the contracts in general. But then more particularly in Chapter 11, we're going to talk about real estate contracts. Real estate purchase and sale contracts. They're hugely important. Conceivably the most important document you'll ever sign. And usually for the biggest hunk of money. I'm going to send you a form for a commercial real estate contract. And we're going to go through it and discuss every single paragraph. What does it mean? How does it affect you? How does it give rights and burdens to sellers and buyers? I want you to have a really good understanding of the contract. And then we're going to have an exam, and contracts are going to be on the exam. What we're going to talk about in class is going to be on the exam we're going to have at the end of class. So, you will be encouraged to ask any whatever questions you have and hopefully get a good grasp on it, because then it'll be part of what's going to be in the exam. Now, the I talked about the midterm ad nauseum, I think. You'll probably have an hour to do it. You probably have 3 or 4 pages of, tell me what are the 2 types of this, tell me what are the 4 types of that. What's the difference between a life estate and a fee simple, stuff like that. And then maybe a couple of essay questions where I ask you to write a half a page. Here's a factual situation. What concepts we've talked about would apply to the situation. So you try to, candidly, you guys know this, you've all been to college, use as many of the buzzwords that we've talked about as you possibly can. You throw all those key terms into whatever it is, anything that might be even relevant, put them in there, because that's obviously where I'm going with it, is to see your use of the vocabulary, your understanding of the terms, and how can you apply those in the real world.
So not so much specific things like, I think the book was talking about 14 days for this, and this stemmed from common law 100 years ago, and.
No, you must have gotten the drift of how little I think of the common law crap. I'm saying we're going to talk about feudalism and allodium. I mean, that's all really interesting stuff if you got the time. But we don't have the time in 8 weeks to get into that crud. Well, what I'm saying is, to me, it's not important in the broad brush concept that you're trying to get of all these concepts to understand how did we get there over the last 300 years.
Right.
It's where are we now? What's the law right now? Now, part of that comes from 200 years of courts giving opinions. But what you just need to know is that courts write opinions, and those are holdings, and they create precedent, and other courts have to follow them, and that's where law comes from, you know. And that would be a great essay answer if I ask you. How do courts create law? They listen to appellate cases. They issue a holding. They have an opinion that explains what it is. That creates precedent, because precedent is something that other courts have to follow when they encounter the same type cases in the future. And that creates a whole area of law for people to know what's the law going to be. That would be 6 or 8 lines on how do courts create law.
Is that which, like 6 to 8 sentences for the answers around?
And I'm going to give you a certain amount of space, and you got to get it in there.
Oh, yeah, I write like that.
There you go. That's to kill the people who were here at 7 o'clock saying I'm not quite finished yet. No, I really, I have a strong feeling on these questions of how long an answer I think is appropriate to get entire credit. And more is not necessarily better if it's all BS. And unfortunately, I'm going to have to be able to read your handwriting. So be it. Print if you can't write. Yes, sir.
So, for the midterm, chapter 1 to 11 is going to be.
Yes, sir. 1 through 11.
Okay.
Yes, sir. 1 through 11. Now, do I recall? Forgive me. Did somebody write to me and say way back when that I'm not going to be there that day?
Yeah.
Is that you, Wes?
Yeah, I pushed that. I'm gonna take my real estate license or course.
Is that what that was that you were going to have to do? You said you were going to have
And
to
then
be
the
out
last
there.
weekend of the thing, you gotta go like the Saturday and Sunday.
Yeah.
I'm gonna do it in April, so
Oh, cool.
I gotta see where it
Half of
falls
is
with the
all the
final.
same.
Huh?
What is in this class, half of it is on that test.
Yeah.
So,
Yeah.
I'm only taking one class now, so I wanna do that during this
So
class.
that's
Sure,
on the
thank you.
s-
So,
on the second.
obviously, you know, if you're throwing up that morning and you're sick and you can't come, well, I'll arrange for you to take it some other time. But anybody who knew they weren't going to be here, I wanted to go ahead and schedule something. Hopefully, everybody thinks they're going to be here, and it just ain't going to be that tough.
Hope so.
Okay, I'll see you next week, and we'll,
How much advance notice do you want if we're gonna miss a course?
how much, what, I'm sorry?
Advance notice.
We're going to miss the test.
I don't need any notice at all. If you don't come, you don't come, you know.
We have a final on the 16th?
On the what?
It's the 30th, I think.
No, the 30th. The 30th.
30th, last day of class. Now, and we're going to talk about that later too. Frankly, I had a little talk with Fred about that this morning as to the folks who were on the NAIOP presentation.
Yeah.
Fred said, don't change the schedule on the class. He said, have the class at 12:30 and we'll have the final at the end. Everybody should be out by noon. He's
Oh, yeah,
confident that
okay.
before noon, you guys will all be done with that. And in addition, he said that all of the work that y'all had to do to prepare for that, all has to be done well in advance.
A week before.
Yeah, so I'm staying with a plan. April 30th, we'll cover the last couple of chapters, including most particularly, I'm gonna have a lengthy discussion on April 30th about mortgage foreclosures, how they work, what they do to people's rights and obligations as second mortgage holders, third lien holders, stuff like that.
Will that be on the test?
That'll be on the test.
If for some reason they have runs long,
I'm sorry?
for some reason they have runs long, will we reschedule?
Got a lot of tabs in that book, man.
Figure it out.
Huh?
Yeah, well.
Said you got a lot of
Fred has-
tabs in that
Fred
book.
has done this any number of times before, and he was confident that it won't. But, you know, I'll hold off starting class. If